Refugee Act. This was not adhered to, in further violation of their right to dignity. And on to the second factor, the purpose of limitation vis-a-vis the limitation in question. It is our averment that according to the fact pattern, there was no substantive reason given to Warido and his family of their holding at Nyairo refugee camp. It is stated, as a reading of paragraph 8 and 9 provides, that they were simply transferred to Nyairo holding center. They were not given reasons or information as to why. And on the third and final factor, whether this was the least restrictive measure, holding of Warido and his family in places that are unsanitary, overcrowded and unsuitable for children could surely not be the best and least restrictive measure. Article 8 of the OAU Refugee Convention provides that states have the capacity or should embrace the capacity to liaise with the organizations such as the UNHCR in matters where there is a large influx of refugees. This was not done by the state of Nyota. They were simply kept in holding centers without reason. And on to the second limb of argument, proving to this court that the holding of the issuance of an encampment order by the Minister of Homelands was actually an unjustifiable limitation of the rights of these particular refugees. On to this factor, we do submit that this particular action is provided and authoritated by Section 31 of the Refugee Act and the Article 26 of the 1951 Refugee Convention. But this does not equate it to being lawful. It also needs to fulfill the factor of not being arbitrary. Seeing that my time is far much spent, I humbly implore this court to award me a discretionary 2 minutes to finish up on my arguments. Okay, much obliged. And in analyzing whether this encampment order was a legitimate limitation, it is our averment that it was not a legitimate limitation. And I will analyze this via a proportionality analysis of 3 factors: its unlawfulness, and there was no nexus between its limitation and the purpose of limitation, and finally that it was not a least restrictive measure. As stated in the first factor, it was provided in Section 31 of the Refugee Act and Article 26 of the 1951 Refugee Convention, but this does not equate it to being arbitrary. And as seen in the fact pattern, there was no rationale given of these particular refugees being held regardless of their health status, regardless of their professionalism or lack thereof, and even regardless of their educational level or the degree that they had integrated into that particular community. This was not analyzed. And on to the second factor, the nexus between the limitation and the purpose of limitation. It is clear in the fact pattern that there was no direct nexus provided by the Minister of Homelands between every individual Zaifandian refugee who was encamped and the order of encampment. This was stated in the case of Attorney General versus Kituo cha Sheria, which was stated that in any matter, a direct nexus of an individual vis-a-vis the threat to national security should be shown. This was not shown by the Minister of Homelands. And on to the third and final argument of the least restrictive measure. This was not the least restrictive measure. The state of Nyota could have even conducted an individualized, targeted investigation of which particular refugee mobilities were being exploited. This was not done, but rather an encampment order that was arbitrary, that was a blanket encampment order, was issued by the Minister of Homelands, contrary to the case of Kenya National Human Rights Commission versus the Attorney General case 2017. And with that, it is our humble prayer, as the appellants, that this court affirms that the actions of the state of Nyota violated the rights of Article 27 of the Constitution of Nyota, Article 28, Article 39, Article 47, Article 50 and Article 53, sub-Article 2 of the Constitution of Nyota, that further these actions violated the obligations, breached the obligations that the state of Nyota has towards the international community regarding refugee matters, and that this, the cost of this particular appeal is borne by the respondents, and further that any other relief that this court may deem fit to be granted as per Article 23(3) of the Constitution of Nyota.
Okay, thank you. Counsel for the respondents, you can proceed.
Before we proceed, it is my humble request that the 3 minutes that has been granted to the appellant's discretionary may be added to our time for fairness.
Your name?
Counsel Gloria Ogwell.
So, Counsel Gloria, your application is premature because you have not even started submitting. So you can only make it when you realize you are running out of time. Yes, but start with the 20 minutes.
May it please the court. May it please the court. I am Counsel Gloria Ogwell, the lead counsel for the respondents. I will be handling issue 1 for the respondents. My co-counsel, the second counsel, will handle issue 2 and 3, Otieno George, and our last counsel for the respondents is Counsel Wakili, Counsel Purity Moshiri. She'll be handling issue 4. If it pleases the court, I wish to proceed. My lords, in time of a refugee influx, the reliance on human intervention is just like using a teaspoon to fetch water from the ocean. It is noble, but it will be painfully slow procedure. The AI is a bucket that the government needs to use in order to expedite this process. It is not a way of substituting human compassion, but it is a way to ensure that refugees are given a more effective, more faster way of addressing their issues and incorporating their needs into the state of Nyota. I submit to this court that the respondents were not in violation with the Article of 47 of the Constitution, Article 50 of the Constitution, and the 1951 Refugee Convention, the OAU Convention on the general aspect of the refugee needs. I submit to this court that according to the UNHCR website, there were over 168,000 refugees in 2024 who were yet to be processed and given a refugee status. This is a matter that necessitates the incorporation of the AIRSD system, because an AIRSD system, it is fast, it is efficient, and it minimizes the chances of human bias and corruption. This AI is given information based on a person's history on the social media, based on their biometric analysis. It is not any data that is just collected outside the facts and given and fed into the system. An AI is a computer that works on the data that is given. It is driven by data it is fed into it, and it is not it is an intellectual way of giving information, ensuring that these intellectual decisions and assessments are arbitrary and not discriminatory in any way. I submit to this court that the applicants who were flagged as high risk, they had a chance to appeal their decisions before the specialized administrative tribunal supervised by the High Court, ensuring that there was procedural fairness. The right to fair hearing was further not violated by the respondents because these people who were flagged as high risk, they had a chance to submit their grievances before this administrative tribunal. It was not just limited to specific persons, but any person who was not satisfied with the decision of the AIRSD system was free to make appeal before this tribunal that was under supervision of the High Court of the Republic of Nyota. I submit to this court that the respondents were not in violation with the 1951 Refugee Convention. According to Article 33(2), the state is permitted to expel refugees when they pose a threat to the national security. On the grounds of posing national security, I pose to this court that given a scenario, a mother wakes up and she's clinging to the dead body of her baby just because the government allowed these people who are flagged to be members of a terrorist group to enter into their country without any verification, after being flagged as high risk, after being flagged as affiliated with a group that is a terrorist attack. I submit to this court that we should take heed to this and see that the matter of national security is of much importance. We as the respondents submit to this court that we are in agreement that all people have equal rights, and I submit to this court that it is a necessary measure that these people who are flagged high risk, that they get checked before they enter into the state of Nyota, and not just to enter into the state. We are trying to curb this. The problem before it extends to a major state. We are curbing it at the start. I submit to this court that this use of the AI did not contravene in any way the 1951 convention. In fact, it was consistent with its national security exemptions. According to the Article 3 of the OAU Convention, it states that a state should take necessary measures to prevent subversive activities of refugees against a member state. I submit to this court that the necessary measures taken by the state of Nyota using this AIRSD system are in full compliance of the law. They are effective. They are in compliance with the law. They are effective, expeditious, and full compliance of the law. The respondents therefore did not violate the Article 47, Article 50 of the Constitution, the 1951 Refugee Convention, and the OAU Convention. I seek to cede floor to my next counsel.
May it please the court. I'm Counsel Otieno, judge of the respondent appearing for the Republic of Nyota in this particular case. My lords and my lady, allow me to draw this to your attention that the principle of non-refoulement, though fundamental, it is not an open gate under which every individual must pass through and question. My lords, this is a bridge that must be guarded by compassion and national security. My lords, allow me to first respond to the submission of my counsels. And they say that the due process was not followed. The result of last resort must be considered for refoulement to be carried out. And that is particularly on substantive issue 2 of the matter. My lords, it is my submission that the principle of non-refoulement is provided for in Article 33(1) of the 1951 Convention of the Refugee, and also it is provided for in Section 29 of the Refugee Act of Nyota. My lords, This provision, we cannot read it alone. We must read it together with Section 29(2) of the Refugee Act of Nyota, which says that where individual is a threat to national security or has a criminal record that pose a threat to community order, then such an individual shall not enjoy the provision of Section 29(1). My lords, allow me to refer you to paragraph 11 of the facts record. And in paragraph 11 of the facts record, following the infiltration of refugee into the Republic of Nyota, we bear witness of four consecutive attacks. My lords, those are our grounds that is a threat to our national security. If we don't pay attention, then there is no way we are going to hold security in our nation, and the eastern region of Adapo continent require peace and stability. If we stay loose by not acting to these four consecutive terrorist attacks on the basis of acting on a strict measure of the principle of non-refoulement, then we are going to lose all our security in the region, in the eastern region of continent of Adapo. So who will be protecting or granting asylum to the people in that region? It is our submission that the due process was followed. For an individual to be refoulement, there must be some criteria that this individual must not have satisfied, and these include this individual posed a threat to national security. And we bear witness that although we were using AI to do the determination, any individual that was dissatisfied with the result of the AI had a leeway or had a platform to do the appeal. My lords, none of this was done. Paragraph 8 of the facts record provides an administrative tribunal to conduct appeal. For individual to claim that the action of the Republic of Nyota didn't follow the due process, then this individual must have been dissatisfied with the results of the AI determination and therefore opted for appeals as provided for in paragraph 8 of the facts record, and the appeal was subject to supervision by the High Court. My lords, he who comes to justice must come with clean hands. If an individual is seeking protection and the same individual has caused chaos from where he or she has come from, then we don't owe that individual a duty of protection. We must protect our citizen and the incoming refugee, but only if they meet the threshold required by our institution, by our state. We enjoy sovereignty as a state, and any individual must satisfy the condition to be protected within the Republic of Nyota. My lords, it is my submission that the principle of non-refoulement was not violated. In fact, the Republic of Nyota act in accordance to the law that it has in Section 29(2) of the Refugee Act of Nyota. And therefore, it is our prayer that this honorable court hold the judgment that was provided by the Court of Appeal. On to the best interest of the child. My lord, the concept of the best interest of the child is a very delicate matter. It's like a delicate flame. It's like a delicate lamp. But it must be handled with care, because the delicate lamp can also burn the individual that is protecting it. If it burns the individual that is protecting it, then who is going to protect this delicate lamp? My lords, it is our submission that there is no definite definition of the best interest of the child. However, this is to be considered on a case-to-case basis. Our Constitution provides for its paramount consideration. However, it must be weighed against some competing interests, and that include national security and the place of family in the development of this child. It is our submission that pursuant to the United Nations High Commission on Refugee Guidelines, we are provided that we must consider the best interest of the child, and factors are laid out in the first schedule of the Children's Act of Nyota. It says we consider age, we consider level of development, level of maturity, gender. But all these factors we must not consider. But the United Nations High Commission for Refugee focuses on the view the child ability to express his or her view of the experience, because it is only the child who can express this view. But it is provided for that under paragraph 66, if this individual, this child and the accompanying individual have the same risk or the same fear of persecution, then there is no need of granting priority to the child. Instead, we can conduct them as one. And that is what we decided, because we were acting within the confines of the high infiltration of the refugee, of the asylum seekers that were coming into our state. It is not that we didn't give a regard to the best interest of the child. It is our submission that we did. And it is our submission that based to paragraph 4 of the same guidelines, we are told that we must consider the level of maturity. The level of the maturity sometimes, if it wasn't required that the child express the view too, and it is our submission that through AI in paragraph 8 we are told it could exhaust the information about these asylum seekers, and therefore pursuant to paragraph 474 of the guidelines, we are required that if the child is not as a position to communicate his or her experiences, it is our duty to go to the state and exhaust all the information, and that is what we did pursuant to paragraph 8 of the facts record. And it is our submission that there was no violation of the best interest of the child. We act within the constraint of what was the best interest of the child in this context, and that was keeping the child together with the parents. We doesn't know the age of the individual, but it is our consideration that these children were young enough, and therefore their best interest was putting them together with their parents. It is our submission that this honorable court may hold the judgment of the Court of Appeal in that particular matter.
May it please the court. My name is Counsel Purity Mushiri, and I'll be handling issue 4. It is our submission as the respondents that we as the Republic of Nyota, we were not in violation of Article 28, the right to human dignity, Article 27, the right to equality and non-discrimination, and Article 39 on the right to freedom of residence and movement. The encampment order was temporary, it was necessary, and it was a proportionate response to the urgent security threat following the multiple attacks which were connected to the infiltration of foreign elements who are exploiting the refugee mobility. The government acted to protect both the citizens and the refugees by ensuring order, safety, and efficient monitoring of the asylum seekers during this time of instability. On the right to human dignity, paragraph 9, in paragraph 9, the United Nations High Commission for Refugees brought a report claimed that the refugees in the processing center, they were subjected to inhumane conditions, and the government responded positively by taking these refugees to the Nyairo Refugee and Holding Center, where there were better standards, where there were better conditions. Though they were not ideal, they met the minimum co-obligation, because in the fact sheet we can't see the appellants claiming that they lacked things like food, shelter, healthcare, and humanitarian assistance. And on the issue of overcrowding and unsanitary conditions, these were due to the influx of these refugees, and the government was trying to work to its own financial capability to take care of the overgrowing numbers of asylum seekers. And on the issue of equality and non-discrimination, we as the respondents submit that we did not violate this right, as the directive, the encampment order, was given to all the refugees who are in the urban centers and who were in the rural areas. This policy was objective, and the objective was to ensure national security and to streamline refugee management. As the Minister of Home Department had claimed that these attacks were due to the unregulated refugee movement, and the government had to respond to this. The root cause of these attacks was due to the unregulated refugee mobility, and we had to address this root cause. And the government addressed this root cause of these attacks by regulating the mobility of these refugees, by keeping them, by sending all of them in one area to ensure proper and efficient monitoring, registration, and identification of these asylum seekers, because the attacks were due to the unregulated mobility. If the government was to adopt less restrictive means as to access them in their areas, it would be so hectic, and the government had to address this root cause of the refugee or of the attacks. And also on Warido's issue on equality and non-discrimination, we as the respondents submit, I pray for an addition of 2 minutes to finish my submission. Yes.
Your counterpart got 2, right?
Yes.
Yes, 3. Okay, so you can have an equivalent one. Within 3 minutes, you can wind up.
Okay, thank you so much. Warida's family were not the only one in the Nyairo Refugee and Holding Center, because we can see the overcrowding. And due process was being followed as the people who were termed as high risk were kept in the holding center. And because these people pose a threat to national security, and it is the duty of the state to ensure there is national security and public order in the state. And we as the respondents argue that the policy was reasonable and it was objective. And the objective part of it makes it time-bound. Because if I have a certain objective, it means that I have a timeline. After I attain that objective, I will let these people go. If you are innocent, you'll go back to your residential area. If you are found guilty, we'll take the reasonable measures upon you. And on the reasonable, the 10-day period was enough, because these people had only stayed there for a month. And this was an urgent matter in the state, which needed an urgent response. And that's why we gave this encampment order. On the freedom of movement and residence, we as the respondent submit to this honorable court that the Republic of Nyota did not violate this freedom of movement and residence, because this freedom of movement and residence can be limited under Article 24 of the Kenyan Constitution in the interest of national security and public order. Also in the African Charter on People's on human and people's rights, Article 12.2, right to movement may be limited to attain a legitimate purpose. And also the restriction was to the restriction of refugees in designated camps was a legitimate administrative measure aimed at ensuring proper and efficient. That's why we needed them to be in one place. Also the United Nations High Commission for Refugees Guidelines on International Protection number 12/2020 acknowledged that states may impose restriction on refugee movement for legitimate security or administrative reasons. And on Warido's case on freedom of movement and residence, in Article 26 of the 1951 Refugee Conventions, it claims that states shall accord this freedom to the refugees who are legally in the country. And these people had not been legally allowed to be in the nation. And it is my prayer that this court may find that the respondent did not violate they did not violate these rights, and to give a go ahead for the encampment order. Thank you.
Okay, thank you so much for the submissions. We want to take a few minutes just to interact with that part. Then we will allow the appellants to do their rejoinder as they respond to any issue that will emerge. This is to Council Onyango. On the issue of jurisdiction, would you mind specifying which jurisdiction? Is it, I hope you understand, specify. Council Munga. This is a little bit generalized, but on the part of the state, the argument by the state in this matter is that they were doing what they need to do as a state actor in order to protect the interest of the public. And using AI was the most convenient way of getting real-time data that is accurate. Now, I would like to hear your comment on the court is required under Article 259 to interpret the Constitution. Among other duties or outcomes is to develop the law. AI is still a new ground in Nyota Republic. Why shouldn't the courts then interpret the Constitution under Article 259 to develop the law on the issue of AI, so that we find what the Court of Appeal arrived at was okay? Just this one is to get your thoughts on it. An argument has been advanced by the respondents that Warido, was a high risk. That is how the assessment indicates. Isn't this then an exclusion clause under the Refugee Convention, so that the state was right in treating him the way it treated him? I think on Council Mushiri, the use of AI is indeed an administrative action, and if so, should indeed be subjected to the provisions of Article 47 of the Constitution, so as we find out if it meets the basic criteria under that article. So those are my few issues for the parties.
Thank you so much for your submissions and your presentations. This goes to the appellants. What would have been different should the best interest assessment on the children have been done? And if so, if the same shows that the child or the children from the best interest assessment, it would have been in their best interest to have remained at Nyota, in Nyota or rather, and the parents deported, what next? What would have been the ideal situation for the children in that sense, in that case study? Then, are there legal provisions that you're aware of in the international statutes and even in our local statutes that would deal with that kind of a scenario, that the children are left behind, the parents are deported? So we also have many Zephyrians, if I've said that right, were at the border. So was this system discriminatory, or was it working correctly in the sense that the system was fed with what it was meant to look out for, and by doing so, then it highlighted that Warido and his family were high risk. So did the system fail? So if the system did not fail, then why the appeal? In the sense that it was working optimally, no one has said that the system was wrong. It is just the issues about that the fair administration of justice, the fair administrative action, and the other aspects that are being raised. But was the system in error? Then the attacks now goes to the respondents. The said system flagged Warido and his family as high risk. And because now you're saying because of national security and looking at the government of Nyota and securing itself. But were these attacks ever linked to the fact that Warido, despite the fact that he was coming from an opposition party, were they linked to the fact that his high riskness was based purely on the attacks and the fact that he was in the opposition party, and therefore the system flagged them as such? If that way, in that sense, then the human aspect that the appellants they've argued about, would it not have been better now for the human aspect to have stepped in and seen why was this family flagged out as a high-risk family, despite the fact that they were in a country where the government ideally was failing, and they were flagged by that government to be in the opposition, and because of that, and maybe some of the few comments that they made, then the system flagged them as high risk, and that is why then, as the Court of Appeal held their decision. I think those are the few questions I have. Thank you.
So thank you very much for those very insightful presentations. I don't think I have very many questions. They have been covered by my colleagues. I think I'll just pose two questions. The first one will go to the applicants, that is the appellants. This goes to Council Munga. In your presentation, you made reference to the fact that by using the AI, it produces data which is both discriminatory and has bias. And maybe my question is, don't you think this is a bit presumptive, because you do not know the data which was fed to the AI for you to assume that the result was discriminatory and with bias? And on the other hand, would you not agree with me that where you have data collected by a human, it will result to more discrimination and bias as opposed to an AI machine? On the part of the respondents, I think I took an issue with a statement which was given by Council Mushiri, where she stated that the freedom accorded to the the freedom is accorded to the refugees who are legally in the country. So my question would be, does that mean that under the refugee laws, if somebody is in the country illegally, they do not enjoy the same freedoms as a refugee who is in the country legally? Thank you.
Yes, we start with the respondents, and then we go to the appellants. Once you are done with the responses to the questions, you will take your rejoinder.
Much obliged, my lords and my ladies. Allow me to respond to this very question. Was the system discriminatory? My lords, I'll answer this very question pursuant to paragraph 8 of the facts record. There were 3 grounds which the system was using to identify or to conduct this decision. And these grounds were history reviews. We have social media analysis and behavioral aspect part of it. My lords, these 3 grounds was conducted to every individual, and it was not discriminatory. And if suppose you felt it was discriminatory, paragraph 8 provide a platform for your appeal. That means you are in discontent of the result of the AI, and therefore it is eliminating the discriminatory part of it, because you have a platform to appeal it. And then, did the system fail? My lords, it is said that machines are sophisticated, but they lack human nature of it. And therefore, it is our submission that the presence of the administrative tribunal was to offer that human part of it. Because My lords, at some point in determining refugee status, we need to understand the context and the circumstance. At that point, we say the system cannot maybe go to the extent of identify the circumstance and context, and the human part in the platform of administrative tribunal will offer you a chance to explain yourself and adhere to fair hearing as provided in Article 51 of the Constitution of Nyota. So human aspect was in the process. So we don't need a human aspect to step in. It was already included, and every individual you would have utilized the appeal platform to see that the decision that was given was really relevant to that of his or her claim. Thank you very much, Your Excellency, my lords and my lady.
To address the question from Her Ladyship about the application of rights to persons in Kenya, I submit to this court that according to Article 26 of the 1951 Refugee Convention, it states that the right to movement, to residence and movement is solely vested on a person who has been granted the refugee status lawfully in Kenya. But we also submit to this court that other rights like rights provided for in the Constitution of Nyota, according to Article 22, they are enjoyed by all persons. I rest my case.
Much obliged. I would like to answer the question on the administrative action from my lordship. In the Constitution of Nyota, it states that an administrative action should be efficient, expeditious, reasonable, and procedurally fair. And on the expeditious part, my co-counsel presented that the United Nations High Commission for Refugees website on 2024, as per 2024, it found out that 168,000 unprocessed refugee data. And the government had to respond to this because it wants to help also these refugees, and it had to come with an alternative way to handle this, and that's why it came with these AIRs, this system, because it is fast and it is fair. And on the fair part, it is that the Republic of Nyota offers a tribunal, an administrative tribunal to handle the appeals. And on the procedurally fair, it is also on the appeal part. It is procedurally fair. The AIRSD system was necessary to handle the influx of the refugees who are coming from Zephyria, maybe other countries where there are civil wars, and the government had to respond to this. That's my submission.
Your lords and my lady, allow me to respond to one question that I happen to have omitted. Okay, so I was asked, was the attack linked to a riddle? It is my submission, my lady, that the attack was not linked to a riddle, and paragraph 12 of the facts record provides that the attack was linked to high infiltration of refugees from Zephyria. That is on paragraph 12. It was not linked to a riddle. It was linked to high infiltration of refugees from Zephyria, and the timeliness of events can also prove that, my lords and my lordship.
Much obliged, members of the bench. In responding to the question asked by your lordship, Kasavuli, as to which jurisdiction are we invoking? It is the position of the appellants that Article 163.4 indeed brings about, confers a right to appeal as a matter of right involving constitutional interpretation and application. It is at the submission of the appellants that the matter before this court raises fundamental questions regarding interpretation of the articles of the Constitution. That is Article 27, 28, Articles 39, 47, 50, and Articles 53 too. It is in this accord that we submit to this court that the jurisdiction invoked is that of constitutional interpretation.
Much obliged, your ladyships and your lordships. On the first question, on whether efficiency and expeditiousness actually was the reason as to why the AI was used, we as the appellants are alive to the fact that there was a need to ensure that every refugee had undergone the refugee status determination. However, we submit that the need for an expeditious decision and an efficient decision should not be used to substitute the other principles laid down in Article 47, that is on legality, reasonableness, and procedural fairness. Further, I agree with you, Honorable Justice Kasavuli. There is a need for this Honorable Court to emerge a jurisprudence that is going to help us with automated decision making. We submit that this Honorable Court, we submit that in reliance with the German case, persuasively, whose rights, the common rights of the people, are actually related to our constitution rights, that is on the right to fair administrative action and fair hearing, that as stated in the case of higher administrative courts, that is the case of OVG versus NRW, a 2023 case, full automation, although efficient and expeditious, if not reasonable, procedurally fair, then can lead to the removal of rights of refugees. It is therefore our submissions that the need for efficiency and expeditiousness should not be used to overcloud justice. On the second question, Your Lordship, we agree that Section 4(1)(d) of the Refugee Act provides for the exclusion if a person is termed to be a national security threat. We, however, submit, as stated in the case of Ntawanda versus Commissioner of Refugee, persuasively, the Court of Appeal, specifically in paragraph 43, stated that there is a need for the respondents to demonstrate that there were serious reasons for considering the exact words used in the Refugee Act. In regards to the seriousness of the situation, there is a need to also analyze the situation at hand in the country. Therefore, if the environment is so peaceful, then therefore a person should not be excluded. Looking at the 4 coordinated terrorist attacks, they happened after Warido had been flagged as high risk. Therefore, not demonstrating that there was a need to ensure our national security. As also, we agree with the counsels for the respondent that they did not show that there was a direct link between the 4 coordinated terrorist attacks and Warido. On the third question, on whether the system failed, because Warido was also affiliated with the Democratic Liberation Party, we as the appellant submit that it indeed failed because it was not able to sieve through the data that was given to it, being that there was prima facie evidence of persecution if Warido and his family would be brought back to the country that they were coming from. This failure to note that there was persecution constitutes a failure of the system. And lastly, to the question asked, Your Ladyship, I would like to direct this Honorable Court to paragraph 8, the first sentence of the compromise, which stated that the AIRSD was using biometric analysis, social media history reviews, and behavioral pattern assessment to make real-time asylum decision. This includes the fact that a government or Warido was flagged as high risk in his own country because the government of the state of Ziferia did not want to let go of the power they had, and therefore, due to the political vendetta in accordance with the state of Ziferia, this is why he was affiliated with the Democratic Liberation Party, as seen in paragraph 4 of the fact pattern. If I may be of no further assistance to this Honorable Court, I'd like to cede the floor to the next counsel.
May it please this court, on the question posed to me by Lady Justice Njagi on whether the best interest assessment of the children of Warido would have warranted or made a different conclusion as per the fact pattern. And also the laws that are to be used in regard on matters best interest determination of the children. It is our submission and answer as the appellants that the UNHCR guidelines of child asylum seekers provides for refugee children guidelines on protection and care, the 2021 UNHCR best interest procedure guidelines, the child asylum claim of 2009, and also the UNHCR guidelines on the formal determination on the best interest of particular children. And if the state of Nyota would have used these particular guidelines that were also used in the case of Refugee Consortium versus Attorney General, a 2015 case, to determine the best interest of these children, they would have come to the conclusion that a best interest determination was now required in order to state or to find out if the remainder of these children in the state of Nyota would have been better for their development. And this would have been better as pursuant to paragraph 3 and 11 of the fact pattern, where it was clearly stated that there was prima facie evidence that these children would face the same atrocities that they had endeavored to escape in the state of Zaiferia. And in reliance to the aforementioned paragraphs and guidelines, if the state of Nyota would have followed these particular laws, they would have come to the conclusion of retaining these particular children even in foster homes in order to ascertain their care and development as indicated in international obligations that the state of Nyota has towards asylum seeking children. If I am of no further assistance to this court, I'd like to cede the floor to my co-counsel who will submit on our rebuttals.
You have 5 minutes.
Much obliged. May it please this court, onto the principle of refoulement. The respondents have submitted that Warido and his family were refouled. This is because they posed a high risk and were considered to be a threat to national security to the state of Nyota. Further, they have invoked the Refugee Act in making this argument. However, relying on the case of Regina versus Pierre Brochu, the court stated that a state seeking to refoul must show that there is a genuine and serious threat that has been linked with the asylum seeking person. However, in the matter before this court, that was not adhered to. The state did not take steps into linking Warido and the family with the threats that they were alleging. Further, the respondents, the third counsel for the respondent has acknowledged the fact that Warido and his family were in fact detained in a government-controlled center. And she has further argued that the conditions, even though they were not as suitable, but they were the minimum core standards. In rebutting that, I would like to rely on Article 8 of the OAU Refugee Convention, which outlines that in such circumstances where there is an influx of refugees, the state should liaise with international organizations. However, in the matter before this court, the respondents have only said that the detaining center was overcrowded due to the influx. However, they took no steps into liaising with the international organizations. Further, the respondents have also submitted that the refugees, in fact, were not legally allowed in the state of Nyota, and therefore the deportation order does not infringe their right. However, Article 20 of the Constitution of Nyota outlines that the Bill of Rights applies to all. The Bill of Rights applies and binds all state organs and all persons, regardless of whether they are the nationals or not, provided they are within the jurisdiction. It is in that accord that we state that even though the refugees were not granted legal entrance, that the laws apply to them and therefore should have been treated as residents of Nyota and nationals of Nyota. If there are no questions from the bench, I cede the floor to the bench for further guidance.
Okay, thank you for this session. We are done, and we are grateful that you have kept time. So the session comes to an end. We will consider your submissions, and a decision will be made later in the day. When we gather, it will be released to the parties. So we can break now.
Good afternoon, and welcome to Supreme Court of Kenya for the moot court competition. The matter is the Nyota Refugee Coalition and Warido versus the Minister for Homeland Security and the Department of Refugee Services. I will welcome the presiding judge to introduce other judges.
Okay, good afternoon all. I welcome you to this session. My name is Bernard Kasavuli. I will be the lead. On my right is Honorable Njagi. On my left we have Honorable Caroline Mugo. So we should be able to start. I'm seeing for preliminary purposes, these are 2 and these are 3. So we just want to be sure that for this team they have 3 oralists and you have 2. Okay, the reason why I ask this is the second scenario we are encountering, and our score sheet has 3 oralists to be marked. So that is how we will proceed on that understanding. Okay. So the court assistant, you can proceed.
May it please the court. For the record, my name is Njogo Kiarie. My learned friend is Frederick Wangila. I am the lead counsel in this matter, and he is the co-counsel in this matter. I will be taking 15 minutes of your time, and my learned friend will be taking 5 minutes of your time. We do reserve 5 minutes for rebuttals. My lord and my ladies, this matter is far more than codes, complex algorithms, and machine decision. It is about what happens when we decide to let an AI decide what it means to be human. When we decide to treat an...
Just a minute, sorry for that interjection. You can repeat your name again for record.
Oh, sorry, my lords. My name is Njogo Kiari. Njogo Kiari.
Kiare.
Yeah.
And you are
Frederick Wangila. My lords, this appeal is far more than codes, complex algorithms, and machine decisions. It is about what happens when we decide to let an AI decide what it means to be human. It is about what happens when we decide to treat an AI as an all-seeing judge, an all-knowing judge that can neither be wrong nor fallible. But my lords, we do know that an AI is only as great as the algorithm that created it. If the algorithm that created it did not create it to take into consideration principles of fairness, justice, to take into consideration fundamental rights and freedom, then the AI is blind and it is fallible. My lord and my ladies, this is a story of Warido, his wife, and 3 children, running away from persecution in Siberia, mass execution, sexual violence targeting women and children, political oppression, and the destruction of their homes and villages. My lord and my ladies, they were met at the border post by an indifferent AI that does not take into consideration principles of justice, does not know anything concerning human suffering, and as we shall prove, does not even know the law. My lord and my ladies, if you will allow, I want to comment on jurisdiction. On jurisdiction, on the case of Samuel Kamau Macharia and another, versus Kenya Commercial Bank Limited, This court, the Supreme Court, ruled that a court's jurisdiction flows from either the Constitution or the legislation, and thus a court exercises its jurisdiction on the basis of the Constitution or any other law. And this court went further to state that a court cannot confer jurisdiction upon itself. The jurisdiction in this matter is conferred in Article 163(4) that states, in any matter concerning the application and the interpretation of the Constitution from the Court of Appeal, this court shall have the jurisdiction. This case involves the application and interpretation of Article 27 of the Constitution on equality, Article 28 on human dignity, Article 39 on freedom of movement and residence, and Article 47 and 50 of the Constitution. My Lord, if you allow, I want to proceed on the first issue. The first issue involves whether the use of artificial intelligence violated Article 47 and 50 of the Constitution, as well as the 1951 Refugee Convention and the OAU Convention governing specific aspects of refugees' problems in Africa. My Lord and my ladies, I will use a very interesting argument, and my argument is that the AI does not actually know the said law. In paragraph 11 of the fact pattern, we are told that no individualized risk assessment was conducted despite there being prima facie evidence of exposure to harm if deported for Rido's children. My Lord and my ladies, Article 53(2) of the Constitution provides that in every matter concerning a child, the child's best interest shall be of paramount importance. My Lord and my ladies, if the AI did not take into consideration the child's best interest, and may I remind the court that on 30th June 2025, this court, the Supreme Court, ruled that in the case of Fatuma Adman Aboud Faraj versus Faith Ruth Mwawasi, that a child born out of wedlock in Islam can inherit, and it cited the child's best interest found in Article 53(2) of the Constitution. If a religion more than 2,000 years ago, founded more than 2,000 years ago, can actually is forced to respect the child's best interest, what about of an AI? It is the submission of the appellant that the reason it is not taking into consideration the child's best interest is because it is actually not created. The algorithm that created it did not create it to take this into consideration. My Lord, tie that to the fact that we see it not taking into consideration the non-refoulement principle founded in Section 29 of the Refugees Act. My Lord and my ladies, when you look at the fact pattern, in paragraph 7, we are told something very interesting, that the AIRSD was created in partnership with a foreign private firm. When you look at the facts and you look that it was created in partnership with a foreign private firm, it becomes clear that the foreign private firm does not know the said law. It created an algorithm that it did not take it, it created an algorithm that does not consider Nyota's law. My Lord and my ladies, on paragraph 40, my lords and my ladies, on Article 50 of the Constitution, you have the principle of fair hearing. Fair hearing involves you being heard, hearing the other side of the story. Reading Article 50 of the Constitution in conjunction with Article 4.3b of in conjunction with Section 4.3b of the Fair Administration Action Act that states that the person shall have a right to actually be heard and actually be given representation. What did we see in our case? In our case, we saw a situation where the AI removed data from the internet, and then it removed data from all, but it did not give them any opportunity to be heard. Nowhere in the fact pattern are we told that they were given any opportunity to be heard. So if they were not given any opportunity to be heard, then how can they be given a fair hearing? If at the very least, they were not even given any hearing at all. My Lord and my ladies, I wish to proceed on issue B of the fact pattern. On issue B of the fact pattern, provides for the non-refoulement principle found under Section 29 of the Refugees Act, founded in Article 2.3 of the Article 2.3 of the OAU Convention governing specific aspects of refugees' problems in Africa, and Article 33.1 of the 1951 Refugee Convention. My Lord and my ladies, currently in the world we are witnessing a massacre in Sudan. I am sure, my lords and my ladies, that you have seen those videos and images emanating from Sudan, where we see blood that can be seen all the way from space. My lord and my ladies, the exact situation is in our case, because in paragraph 3 of the fact pattern, we are told that there is mass execution in Siberia. Similarly, in Sudan, there is also mass execution. We are told in our fact pattern that there is political oppression, that there is destruction of villages and homes, and similarly, in Sudan, there is the same thing. But my lords, suppose that there wasn't even any law concerning the non-refoulement. Will it still be legal to deport Warido? And my answer of the appellant is that it will not. This is founded in Article 25A of the Constitution that states that among the rights that shall not be limited under Article 24, because Article 24 provides for limitation of rights, are freedom from torture, cruel, inhumane, and degrading treatment or punishment. My lords, in paragraph 4, it is very clear that Warido and his family, Warido and his wife, were subjected to torture, detention, and they were subjected to all forms of torture. So even if there was not any principle on the non-refoulement, by the basic value of Article 25A, freedom from torture, then it will still be illegal. Because it will be very hypocritical to say that us as a nation, we don't torture. But what we do is that we do return you to a country where you're actually going to be tortured. My lords and my ladies, that will be very hypocritical, and that will be very hypocritical. My lord and my lady, allow me to proceed to issue C of the fact pattern. Issue C of the fact pattern, we are told that it is concerning the child's best interest. My lord and my ladies, on 30th June 2025, this court, the Supreme Court, released a ruling that sent shockwaves across the country when it ruled that a child born out of wedlock in Islam can inherit. In the words of the learned judges, they said that the sins of the parents should not be visited on the child. My lord and my ladies, in this case, even if you are to grant that Warido is a terrorist, which actually Warido is not a terrorist, because if you look at paragraph 3 of the fact pattern, the same government telling us that Warido is a terrorist is the same government that refused to cede power, is accused of electoral malpractice, and as the name suggests, of the party is accused of belonging. It's Democratic Liberation Party. This is a party that is fighting for democracy and human rights in Siberia. And the Siberian government, in an attempt to oppress this party, decided to label it as a terrorist organization. And going back to Article 50, had they been given an opportunity to be heard, they could have brought this forward. They could have said that the party that we are being accused of belonging, being told that it is a terrorist party, it is actually not. Because the state government that is calling it a terrorist party is the same government that refused to cede election, is accused of electoral malpractices that resulted in all this civil war that has resulted in mass execution, sexual violence targeting women and children, and destruction of villages, and so on. So it can only be clear that we cannot trust this government. And the AIRST, like any AI, it just went and saw that this party has been cited as a terrorist organization and just removed. It did not do its own independent verification. My lords and my ladies, we have done that. We, the advocates of the appellant, decided to actually do our own private investigation, and we did conclude that the party that is being accused of being a terrorist organization is just a party fighting for democracy in Siberia. My lords and my ladies, Article 53(2) is very clear. In every matter concerning a child's best interest shall be of paramount importance. Is it on the child's best interest to deport them to a country where tomorrow all of them are going to be killed? Because as we are being told in paragraph 3 of the fact pattern, that there is mass execution in Siberia. So there is a probability we can deport Warido and his children, and tomorrow all of them are going to be killed. Is this in their best interest? That's why I'm tying this situation to the atrocities that were being committed in Sudan. Suppose the Sudanese wanted to seek asylum in Kenya. Would it be in the best interest of this child to deport him into a country where blood is being seen all the way from space, where we are seeing a woman being tied to a tree and beaten, where we are seeing a child being shot, and before being shot, the child is reciting the only thing he knows. The child is reciting the Quran, then it goes on to be shot. Would it be on the best interest of the child? My Lord and my ladies, this is the question the respondents have to bear. And my Lord and my lady, this being the second appeal, the facts are not in issue. The facts are very clear. That as we see in paragraph 11, and may I repeat that the facts are not in issue by virtue of this being a second appeal. As we see in paragraph 11 of the fact pattern that no individualized risk assessment was conducted despite there being prima facie evidence of exposure to harm if deported for Arido's children. My Lord and my ladies, those facts are not in issue. The facts are clear. Article 53(2) of the Constitution on the child's best interest was not taken into consideration. My lords and my ladies, furthermore, we have Article 53(1)(d) that provides a child has a right to be protected from abuse. And I ask again, how are we protecting a child from abuse if we are deporting this child back into a country where there's all the atrocities that are mentioned in paragraph 3? We have destruction of their villages. We have ethnic persecution. These people can be raped. We are talking about rape. As we see very clearly in paragraph 3, there is sexual violence targeting women and girls. So it is to the respondents to show this court that it is on the best interest of these children to go back to a country where they can be raped. We say the obvious. We say that it is not on these children's best interest to go back to a country where they can be raped. My Lord and my ladies, having said all that, I wish to donate my remaining time to my colleague. Thank you for your time.
As stated earlier, for the record, I'm Frederick Wangila, the counsel for the appellant. So I'll be dispensing on the fourth issue, which states whether the court erred. Whether the court erred that the encampment order by the Minister of Homeland Security and holding Warido and his family of Nyairo in the Nyairo Refugee Center was in violation of Article 27, Article 28, as well as Article 39 of the Constitution of Nyota. So in this matter, I will be inviting the court in a case decided in 2014, the Court of Appeal, whereby the court had the same issue, the same facts, but it decided in a different version. This case was on Attorney General versus Kituo cha Sheria and 7 others, whereby the court decided the opposite on what it's saying in our very own case, whereby in this matter we see Nyairo refugee camp was very overcrowded, unsanitary, and unsuitable for children. In that case, there was no dignity not only to the children of Nyairo of Warido, as well as the Warido himself and her wife, whereby these people had dignity, pursuant to in the virtue of Article 28 of the Constitution. That dignity must be respected. For them being asylum seekers, pursuant to persecution in their own home, so they had to be treated to be welcomed as great visitors and be treated pursuant to the rules of natural justice, whereby there should be social justice. And in the same note, I will be inviting the court in the relooking on Article 10 of the Constitution, which provides for the values of justice, like social justice as well as protection of the marginalized. In the question, the Warido and his family are the and the marginalized people. So on that, I will move to the second limb of my argument, where is the protection of the right to freedom of movement and residence. The right to movement, to residence, to movement, freedom of movement and residence. The movement of Warrido has been curtailed. It's been placed in an automated, whereby there's in an automated facility where there's minimal interaction with other human beings, as well as his movement has been regulated. Then his communication is also limited. Is this justice? That's the question to the respondent. And what amounts to justice? So on the same note, we see in paragraph 10, paragraph 11 of the factum sheet, whereby there was no hearing, no notice, no individual assessment of their life if they are being deported back to their nation on the encampment order. And finally, on that third limb, on Article 27, which provides for equality before the law. As I dispensed earlier, these people, the states of Nyota, through the Minister for Homeland Security, did not provide equality for these people before the law, whereby they were never given a chance. They were never given a chance to prepare the evidence, as well as the states make a ruling of deportation on a mere facts, mere speculation and that these were terrorists, on just subject on them being associates to the said DLP in their country. As a state, as the respondent as a state, they had the mandate to conduct their own investigation based on human oversight, which could come to the conclusion of a better version of the said. With that, I will invoke one of the paragraphs in that case law of Attorney General, whereby the state cannot avoid accountability under the Bill of Rights, reciting national security or administrative convenience in the blanket of terms, and then insisting that the courts must shut their eyes to the hardship in those affected. Here it's clearly these people have been violated. The rights of Warrido has been violated. So as a court, we invite you to consider to interpret the law in a technical meaning and rule in their favor. If you could allow me, my lords and my ladies, 1 minute for me to read my prayers. So the prayers for our prayer.
You have sought for additional 1 minute.
Okay. Yes.
You are granted a minute.
So our prayer is for this court, this honorable court, the Supreme Court of the land of Nyota, to set aside the ruling of the Court of Appeal and uphold the wisdom that was passed by the High Court in some months back. Thank you. It's been a pleasure to address this honorable court.
Yes, respondent.
May it please this honorable court. My name is Felix Mbugwa, the lead counsel for the respondents, representing the Attorney General of the State of Nyota. Alongside me are counsel Susan Kavulani and Deborah Mutia, and I shall use 8 minutes to canvass grounds 1 and grounds 4 of the appeal, while my co-counsel Susan and co-counsel Deborah will use 6 minutes each to canvass grounds 2 and 3 respectively.
Sorry, counsel, your name?
My name is Felix Mbugwa.
Mbugwa.
Yes, Felix Mbugwa.
The second counsel's name?
Susan Kavulani. Susan Kavulani.
And the third one?
Deborah Mutia. Deborah Mwende. Let's use Mwende. Deborah Mwende.
Thank you. Can I start?
My lords and ladies, the state of Nyota is a state that pays keen attention in upholding the human rights of every person. This includes the right of the asylum seekers. The state of Nyota followed the relevant procedure in receiving the asylum seekers. My lords, the respondents shall not object to the jurisdiction of this court. I shall turn to the first ground of the appeal, that the Court of Appeal was correct in holding the use of artificial intelligence system without alleged sufficient transparency, human oversight, or accountability was in violation of Article 47 and Article 50 of the Constitution of Nyota. My lords and ladies, the appellants have clearly submitted that the AIRSD was not in recognition of this law. However, my lords and ladies, in my submission, I shall demonstrate how this artificial intelligence system was indeed in line with the laws of the state of Nyota. My lords and ladies, let's first acknowledge that technological advancement is an inevitable, it's inevitable, and it's coming to us, my lords and ladies. Governments all over the world are using artificial intelligence system in their administrative processes, and as such is the state of Nyota. My lords and ladies, we do note that under paragraph 7, the state of Nyota was in partnership with a foreign firm in developing this artificial intelligence system, my lords. My lords, the words of interest is that it is in partnership. In regards to that, my lords and ladies, I shall turn to section 26 of the Refugee Act that states that section 26 of the Refugee Act provides the function of the reception officer. These functions are: 1, the issuance of application forms; 2, taking photographs and biometric data for asylum seekers; and 3, questioning and searching any persons of interest, my lords and ladies. This was done by the artificial intelligence system through social media history review and biometric analysis, my lords and ladies. Thus, it is a respondent submission that indeed this artificial intelligence was in accordance with the laws of the state of Nyota. My lords, the respondents have submitted that we did not accord the appellants the right to an opportunity to be heard, my lord. My lord, in regards to that, I shall rely persuasively in the case of Simon Gakuo versus Kenyatta University and others, a 209 case before the High Court, whereby it was held that this right to be heard does not fully mean a fully adversarial hearing, my lords and ladies. Further, I shall rely in the case of Republic versus Aga Khan Education Service Board and others, a miscellaneous application before the High Court, whereby it advanced this and said that not every situation requires a hearing, my lords and ladies. There are situations where a hearing would be obstructive, and as such is the case presented before this honorable court. My lords and ladies, paragraph 4 of the fact sheet, we see there are thousands of Zuverian refugees fleeing their home state, my lords, and coming to the Republic of Nyota. My lords, thousands of refugees. My lords, according each and every of these refugees a hearing, my lord, would have stalled the administrative process of refugee status determination. My lords, here we see an artificial intelligence system that is actually expeditious. We see an artificial intelligence that is actually efficient, my lord. We see it even conducting a behavioral pattern assessment, something that was not designated for the reception officer to do such a duty, my lords and ladies. And thus, my lords, the artificial intelligence system was a practicable solution to these thousands and thousands of refugees that are fleeing their home state and needing to go through this administrative process for them to be registered as refugees in the state of Nyota. My lords and ladies, we do acknowledge that we did not provide an interview to them. However, we provided them an opportunity for an appeal, my lord. As seen under paragraph 8 of the fact sheet, there is a small administrative tribunal set to hear any appeals from any decision by the artificial intelligence system. Further, section 14 of the Refugee Act provides an appeal committee against which any decision by the commissioner, they can appeal to that, my lords and ladies. We do note that from the fact sheet, Mr. Warido did not pursue this remedy, my lords and ladies. And thus, we pray that this honorable court that finds that the state did not violate Article 47 and Article 50 of the Constitution of Nyota. I shall move to the fourth ground of appeal. That's the encampment order by the Minister of Homeland Security and the holding of Mr. Warido and his family was not in violation of Article 27, 28 and 39 of the Constitution of Nyota. My lords and ladies, indeed, the state of Nyota issued an encampment order. It was a limitation to the rights of the freedom of movement. However, my lord, the state of Nyota limited this right in accordance with Article 24 of the Constitution of Nyota, which provides that any limitation must be lawful, reasonable, and justifiable. My lords and ladies, we see under Regulation 3 of the Public Security Regulation, it provides that a minister can issue a detention order, can issue an order to detain the freedom of movement where there is instances of public insecurity. And as such, we see under paragraph 12 of the fact sheet, my lords, we are having 4 coordinated attacks, my lords. And with our own investigation, my lord, it is established that these attacks are done due to the refugee, sorry, my lords, pardon me. These attacks are connected and linked to the infiltration of the foreign elements exploiting free refugee mobility. My lords and ladies, as seen under paragraph 4, there are thousands and thousands of refugees fleeing from a state where there is insecurity, fleeing from a state where there is civil unrest, my lords and ladies. And thus, it is justifiable for the state of Nyota to protect its own national security and link these terrorist attacks to these refugees that are fleeing into the state of Nyota. My lords, I shall rely in the case of Republic versus Minister of Health and others, a 2018 case decided before the High Court. It established the precautionary principle, which mandates the state to take protective measures in such instances. And as such, the state of Nyota took a protective measure to protect its own citizens against, my lords and ladies. The state of Nyota weighed other options in regards to other less restrictive means in regards to this freedom of movement. And it's so. We have national public security here, and we have freedom of movement of the refugees. We see that they are fleeing from a state that has terrorists and that has civil unrest, and we see that we have a state that is peaceful and has peaceful citizens, my lords. We favored our own citizens and regarded that we need to protect our own interests, our own security, our own public, our own civilians, my lords and ladies. In regards to the alleged violation of the right to equality, my lords and ladies, I shall persuasively rely in the case of Ram Krishna Dalmia versus Justice Tendo, a Supreme Court of India decision decided in 2002. It held that a state can uphold differential treatment whereby it is based on intelligible distinction and it serves a legitimate government objective, my lords and ladies. Intelligible distinction, we see there are thousands of refugees coming into a state, and we also see that there are 4 coordinated attacks, my lord. It is intelligible for the state of Nyota to limit this right of freedom of movement in regard and associate these terroristic attacks to the variant refugees. My lords, in regards to the violation of the right to human dignity, my lords and ladies, we do acknowledge that the conditions of these refugee acts are described to be unsanitary, overcrowded, and unsuitable for children, my lord. However, my lord, we do rely in the pronouncements of Mutual Welfare Society versus Kenya Airport Authority, a 2021 case decided in Supreme Court of Kenya, whereby it held progressive realization of such rights, my lord. We do acknowledge that the right to human dignity is immediate to these Asgiveran refugees. However, this Warido and his family. However, we see that there are thousands of refugees, and we also see a state that is truly struggling truly trying to progressively realize this by including the artificial intelligence system in its refugee status determination process, my lords and ladies. Therefore, my lords, I shall invite the next council.
May it please this honorable court, my name is Susan Kavulani, as earlier introduced, and I'll be appearing on behalf of the respondents to address the second ground of appeal, that is, on whether the Court of Appeal erred in finding that the deportation of Warido was lawful and not in violation of the principle of non-refoulement. My lords and my ladies, the respondent tacitly acknowledged the profound importance of this principle, that it is the cornerstone of international refugee law and a peremptory norm. However, my lords and my ladies, it was never intended to be a suicide pact for the host nation, and that it's making the allies exception to create a balance between the needs of the society and also the rights, individual rights of the asylum seekers. I'll address this issue under two fundamental limbs. First, on the limitation of the principle of non-refoulement, and secondly, on the justifiability of national security to override this principle. Moving on to our first limb of argument, that is on the limitation of the principle of non-refoulement. My lords and my ladies, the very same law that establishes the principle also establishes its limits. Section 29(1) of the Refugees Act provides that a person shall not be returned to an area is facing persecution. However, this all is scrapped by Section 29(2), providing that the benefit of non-refoulement may not be claimed by an individual whom there are reasonable grounds for him to be regarded as danger to the national security of Nyota. My lords and my ladies, the appellant submitted before this honorable court that indeed it related to Article 25. It related to Article 25 of the Constitution of Nyota. However, we say that yes, it relates to the article, but however, it can be limited. It's not absolute according to Article 25. However, there's a limitation that has been provided for it under Article 33(2) of the 1951 Refugee Convention. This is national security, my lords and my ladies. Therefore, Warido, being affiliated to this Democratic Liberation Party in their home country, it was a terrorist organization, and therefore the state applied precautionary principle in shielding its society. It had to put the interest of the society before. And this will directly lead me to my second limb of argument, that is on justifiability of national security to override the principle of non-refoulement. My lord and my ladies, Article 238 of the Constitution of Nyota provides for the state's obligation to ensure the security of its people against any threat. This is from Section 4D of the Refugees Act provides that a person shall be excluded for refugee determination if there are reasonable grounds, and I'll stress reasonable grounds for him to be regarded as danger to national security of Nyota. My lords and my ladies, we acknowledge that this is not a blank check, that a threat must be serious and genuine. And the threat posed by Warido was precisely that. First, the AIRSD screening system flagged Warido and his family as high-risk profile, stemming from the fact that in their home country they are affiliated to this Democratic Liberation Party. Therefore, they are likely to pose a threat to the national security of Nyota. Subsequently, my lords and my ladies, the state relied on in the 1977 case of Reg versus Busho persuasively that indeed this was really genuine. Any reasonable grounds guarantees the state to limit this right. Therefore, the submissions before this honorable court that the state did not act in defiance of its legal obligation. However, it acted within the explicit exceptions provided for within the law, and that the deportation was therefore lawful, necessary, and a proportionate act. Having submitted on my issue, I'll yield the floor to the third counsel.
May it please this court. My name is Deborah Mwende, appearing as the third counsel on behalf of the respondents. And in the 6 allocated minutes, I shall address this honorable court on the third ground of appeal and conclude with our prayers. Turning to the third ground, that the Court of Appeal did not err in holding that the failure to conduct a best interest of the child assessment was not in violation of Article 53(2) of the Constitution of Nyota and the UNHCR guidelines on children asylum seekers. We acknowledge that children need special protection because they are among the most vulnerable members of our society. And it is in that regard that we concede that as a state of Nyota, we upheld the best interest of the child, contrary to the appellant's submission. And I will proceed to demonstrate that to this honorable court by arguing that the AIRSD conducted a continuous and systematic assessment that truly upheld the best interest of the child. My lords and ladies, it is true. Article 53(2) of the Constitution of Nyota enshrines the paramountcy of the best interest of the child in every matter concerning the child. Notably, we persuasively rely on the 2008 UNHCR guidelines on the determination of the best interest of the child, where it is provided that a best interest assessment is not a rigid formal procedure, but it is a continuous systematic process from the moment a child is identified as at risk until a durable solution is implemented. Following the aforesaid, my lords and ladies, I would like to direct this honorable court to paragraph 7 and 8 of the fact sheet, where upon arrival to Nyota of Mr. Warido and his family in July 2021, the AIRSD conducted a continuous and holistic evaluation of the family's circumstance using biometric analysis, social media history reviews, and behavioral pattern assessments. It is also key to note that this AIRSD system was subject to human oversight via an administrative tribunal that was subject to supervision by the High Court. Therefore, the decisions were not solely automated, consistent with Section 35 of the Data Protection Act. Moreover, we therefore submit, sorry my lords and ladies, we therefore submit that this process ensured speed and accuracy, eliminating human bias and prioritizing family unity, a core component of a child's best interest. Moreover, it allowed the officers to conduct a swift analysis where, in the face of an influx, where delay could have caused greater harm to the children. That being so, we submit that the systematic family-based assessment conducted by the AIRSD meets the basis of Article 53(2), since the best interest of the child was upheld through swift protection, quick processing, and family unity. It is also of concern that the appellant submitted that the sins of the parents should not be visited on the child. While we do respect their submission, it is important to note that paragraph 4 of the fact sheet provides that Warido and his family fled political persecution and that the family was by fact affiliated by the Democratic Liberation Party. The family, my lords and ladies. Therefore, the children are not paying for anyone's sins. This is as per the facts accorded to us, and we tailor our arguments on these facts. Having submitted on my issue, I will now turn to our prayers. The respondents pray that this honorable court rules in favor of the respondents generally and particularly, and that 1, this honorable court declares that the use of the AIRSD system in processing Warido's family's asylum claim complied with Article 47 and 50 of the Constitution of Nyota, the 1951 Refugee Convention, and the OAU Convention. That 2, this honorable court declares that the deportation order issued against Warido and his family was lawful under Section 29 of the Refugee Act, Article 33 of the 1951 Convention, and Article 2(3) of the OAU Convention. That 3, this honorable court declares that the respondents upheld Article 53(2) of the Constitution of Nyota and the UNHCR guidelines. That 4, this honorable court declares that the temporary confinement of Warido and his family at the Nyairo Refugee and Holding Center was lawful and constitutional under Article 28, 27, and 39 of the Constitution of Nyota. That's 5. This honorable court grants such further orders or reliefs as this honorable court may deem just and expedient. The respondent respectfully cedes the floor back to this honorable court.
Thank you for your submissions. Only for us to find out if the court has some questions for you. If we do, then you will respond. The first party to respond will be the respondents, followed by the appellants, who after responding you will then use your 5 minutes to do your rejoinder. On my part, I do not have any question for you.
Thank you so much for your presentations. Just one question on the aspect of Article 39. wasn't there a reasonable regulation because of the high risk aspect? When you're looking at the case of the appellants, was it reasonable for them to be held as high risk because of that? Looking at Article 39. And then in looking at the right, is it an absolute right? Also looking at the issue of the camp, weren't there others also who were placed at the said camp? What was so special about this family for them to go to this camp? Thank you. Not to go to this camp, yes.
Thank you very much for those very insightful presentations. I only also have just one question, or maybe just a clarification, not a question per se. And this is going to go to our last presenter, that is Mwende. You made a comment that in this case, there was no persecution of the children because as per the fact sheets, it was the family of Warido as a whole. So maybe the question I'd want to pose to you is, by your definition, does it mean that if your parents are suspected to be involved in terrorism activities and it states the family as a whole, as a child, you are automatically put in the same bracket because this is the family, that now since you're a child of these parents and they have said the family of Warido and you're a child in this family, it automatically means that you're also affiliated with these terrorism activities. Thank you.
Yes, we may start with the respondents to the questions first.
Your Ladyship, much obliged. I do note your concern. However, my lady, it is important to note that our submission, rather, was targeted at showing that we didn't solely put these children aside and say that just because you are part of this family, you're also linked to a terroristic group. It is key to note that there are children who are in conflict with the law. And so, my lady, being that we have submitted on that, it will be quite, I seek to rephrase. Being that we have submitted on that and that we know that there are some children who are in conflict in the law, it is a precautionary measure that we want to put these children, or rather that we state that it's not targeted on the aspect of being a family alone.
My lord and my ladies, thank you for the question. The first question was on Article 39, whether it violated the holding of these people. My lords and my ladies, I would like to take you in paragraph 9 of the fact pattern, where we are told that the conditions of this camp were reported to be inhumane by the United Nations High Commissioner for Refugees. Furthermore, we are also told in paragraph 10 that they were overcrowded, unsanitary, and unsuitable for children. My lords, the conditions themselves were not in accordance with the status that this country should have, because these conditions violated even their simple rights to health. These conditions were overcrowded, they were unsanitary, and many diseases could have emanated from this. So my lord and my ladies, it is not that this family was so, on the second issue, it was not that this family was so special, but rather that the conditions that they were placed under, an overcrowded condition, a condition that are unsanitary. We are told that in paragraph 9 of the fact pattern that were reported to be inhumane. So if a condition is reported to be inhumane, and bearing in mind Article 25A of the Constitution that provides among the rights that shall not be limited is freedom from torture, cruel and inhumane. The word is cruel and inhumane treatment. These rights cannot be limited under any circumstances. I hope I've answered your question.
Council Kiaria, right? You are for the appellant. Do you want to exercise your right of rejoinder?
Yes.
Yes, proceed. For 5 minutes.
My lords and my ladies, one of the issues that I've noticed by the respondents is on trying to take away from Article 25 the words of Article 25 that among the provisions that shall not be limited is freedom from torture, cruel and inhumane treatment. They have quoted the 1951 Refugees Convention. My lord and my ladies, any law student knows that the Constitution is the Supreme Court, is the supreme law in this country, and any law inconsistent with the Constitution is inconsistent to the extent of its inconsistency. My lord and my lady, can we surely quote the 1951 Refugee Convention when Article 25 of the Constitution is there? I submit we cannot, because the Constitution is the supreme law in our country. Furthermore, my lord, I would like to take your attention to Section 35 of the Data Protection Act, which provides that every data subject has the right not to be subjected to a decision solely based on automated processing, including profiling, which produces legal effects significantly affecting the data subjects. My lord and my ladies, the legal effects were produced in this case, and the AIRSD was a solely automated data processing facility. This is in violation of Section 35 of the Data Protection Act. My lord and my ladies, we will be asking you to rule that based on the condition that these people face themselves, that they could not have consented, because the condition that nullifies Section 35 is had they consented. These people are running from inhumane treatment. They were running from their children being raped, their women being raped, sexual violence. They were running from the destruction of their villages. So it could be they were not placed in any position where they could have consented. If my lords and my ladies decide to stand with justice today and rule in favor of the appellants, then the AIRSD cannot be legal because it violates Section 35 of the Data Protection Act. My lord and my ladies, what has been one of our main arguments is that the AIRSD does not know the law. And we have presented it very simply. We have quoted paragraph 11 of the fact pattern that no individualized risk assessment was conducted, despite there being prima facie evidence of exposure to danger if deported. My lord and my ladies, this is a second appeal. In our second appeal, the facts are not in question. It's only the law. My lord and my ladies, if the facts are not in question, and the facts in paragraph 11, as the respondent themselves can read and affirm, state that no individualized risk assessment was conducted, how can they come and say that Article 53(2) that provides in every matter concerning a child, the child's best interest should be considered, was followed? That they're actually going against their own logic in stating that. And we used paragraph 11 to show that the AIRSD does not even know the law, unless they can show that it was created to know the law, but specifically jump Article 53(2) of the Constitution. Unless they can show that it was created to know the law, but specifically jump Article 25A on freedom from torture, where we have argued you cannot say that you are against torture, but what we do is actually deport you back to a country where you are going to be tortured that is actually hypocrisy. So unless they can argue that it was created to know the law, but just avoid these sections or these articles of the Constitution, then they're actually contradicting themselves. Furthermore, my lords and my ladies, you have Section 29 of the Refugees Act. When you look at the fact pattern, it becomes clear that these people were running from terror from their home country. Section 29 provides that you're not supposed to deport a person back to such a country where he's going to face persecution on the basis of race, religion, and nationality, or political opinion, or belonging to a political group. Warido, as you see in paragraph 4, is being persecuted for belonging to a political group, the Banned Democratic Liberation Party. Furthermore, one question that I will ask the respondent is simple. The last question.
Sorry, you are doing your rejoinder, which has 5 minutes. So you are done with the 5. Would you want a minute or a second?
A minute just to ask the last question, kindly.
Okay, I hope you are not asking a question, but you are doing a rejoinder based on what has been said.
Okay. My lords and my ladies, we do say that when we look at all these facts and what they have presented, it becomes clear that our position is the correct one, because our argument is simple, that it doesn't know the law. Unless they can prove that it just conveniently does not know this said law. And when they quoted paragraph 7, and we said that this AI was created with a partnership of a private foreign technology firm, that is proof that maybe some of this part that it doesn't know the law was the work of this private foreign firm, because I think we have provided enough reason to show that it doesn't know the law and it is ignorant of the law. Ignorance of the law is no defense, something the AIRSD could have known if it indeed knew the law. With that, I would like to end. Thank you.
So thank you very much to both teams. We are done with this session. The court will consider your submissions, and in a short while we will make our decision on it, which will soon be communicated to the parties. So for now, we are done. You may arise. Silence, please. Good evening, everyone. We were here several hours ago in the morning. Now we are back. We have listened to all the 16 teams in different courtrooms. I hope you enjoyed the exercise. So time has come for us now to hear what is the outcome of all what we have been submitting on. This is how I would like us to do it. We want to give you our feedback on how we have seen everything. So on the part of the court, I will give the feedback. On the part of the memorials, there is also a team that will give their feedback. The team that will be doing that, it comprises of Peter Kerr. Peter Kerr is the gentleman here. We also have Walter, Sam Nyambane, we have Faith, and Helen. So this is the team that will give you their feedback. So before I give feedback on what we witnessed during the hearing, I would want to give a chance to our colleagues here to give us a feedback on the memorials. Because if you read the rules, your score, final score for today, comprises of what you scored in the memorials and what you have scored in the oral submissions. So Walter, kindly come and just give them feedback on what you found out.
Okay, thanks, Honorable DR. So from the memorials that you submitted, we marked them, and let me start by commending you. I think most of them were really impressive. So in fact, I think you scored above average, almost all of you. So one major outstanding thing is that the first impression is about formatting, yeah? Before even you go to content. Some of you, at this level, we are assuming as if you are appearing before the Supreme Court. So really that, you must have that good presentation. So you find that some were not formatted, some you still find typos and all that. So you see that already leads to reduction of points. Then in terms of substance, of course we really wanted to see, and that also maybe will come from the judges, the integration of the Supreme Court's jurisprudence, yeah? You find that where we'd see situations where mostly you rely so much on the High Court jurisprudence and not the Supreme Court, where the Supreme Court has a jurisprudence on the same point. In terms of our hierarchy of courts, the decisions of the Court of Appeal and the High Court are just persuasive, yeah? But the Supreme Court, that's binding. So that's in terms of content. But otherwise, I think generally, it shows that most of you appreciated the issues in question, and then I think it was that I'll just commend you to continue it that way. Thanks. Any of you, any other feedback? Care? Okay, Care seems to have something you can say.
Good evening, everyone. Just to add on what my colleague has said, I think there is something else that we are trying to test at this level, and that is your ability to come up with an argument. Remember, all of you are given the same facts, but in terms of the argument, we needed to have that eureka moment where someone puts up a point and you say, wow, okay, this is it. But because some of the memorials you could see, instead of really giving an argument, you'll find that people are merely restating the question. So you see, the question was whether this and this was contravening this particular provision. So you'll see some people just say, our argument is, yes, it contravenes. You see, yes, that is an argument. But we want to see now the argument. Why? Not giving us the same question in positive and negative answer. So that is one of the things that came out strongly. And just out of curiosity, did you find any of the sides easier to argue in terms of being applicant or respondent? Which side was easier? Randomly? Which one were you more comfortable arguing? The applicant's case. Okay, that's interesting. Then there was a part, if you could have seen from the rules, about the affirmation of jurisdiction. Remember, under the question, we had been informed that the jurisdiction of the court is admitted. But what we are trying to test at that point is, of the many jurisdiction that the court has, which one exactly is it? So when you say the affirmation of jurisdiction, we're expecting that you will say, yes, we are coming, but under this particular type of jurisdiction. And then, like Walter has said, again, we saw most of the memorials were quoting the international instruments. So you are quoting the European Court, the African Charter. So again, when you look at our hierarchy of laws, I know you know about Article 2.4, there's a context within which they can be applied. So that is also something that we're trying to look out for. Otherwise, from where I am, I think I was impressed, at least from what I got to see, and I saw quite a many of them. And we had this discussion, and I think it can only mean that we are going somewhere. And thank you very much for making us enjoy to see your work.
So that is on the part of the team that looked at your memorials in full. We invited 18 law schools. You must clap for yourself because, yes, just clap for yourself. Because out of the 18, only 16 managed to put in their submissions within the time that we had indicated. And this time round, unlike last year, you had more time. Last year, we were doing the moot court in November, and we were sending the moot question around October there. But this time round, we decided we want to do it early, so as the mooters have enough time within which to do their work. And then also those who are marking, they also do it within their work. So let us go to what did we witness during the hearing. There was a lot of courage in what we witnessed. The power and the passion with which the submissions were being made, the judges really liked them. I know they would have wished to be all of them, but due to constraint of time, they have had to leave. But I have gathered from all of them what they each witnessed from those who appeared before them. So they saw a lot of courage in you, because at this level, it's the Supreme Court level. So, and that is the lens in which we are viewing every person who appears to make an argument. So with them, they look at it and they are like, oh, in which year this one? Are they in fourth year or first year? Are they in university or law school? But we tell them these are university students. So you see, you impressed them in the manner in which you made your argument. Most teams were well prepared for this occasion, and you could see it from the manner in which they were advancing their argument. You look at it and you say they were prepared well in advance. Another thing, most of us, we were audible enough, because in a court of law, being audible, it's an advantage, because you attract the attention of the judge who is listening to you. But if you are not audible enough, sometimes our energy levels have gone down, so you are making them to go down more by not being audible enough. But thanks, most of you were that audible enough. Persuasiveness, if you looked at what we were looking at from the hypothetical, from the rules, it carries a very good percentage of the marks we were looking at, how persuasive you are. So the posture you take, how you do your intonations, how you face the court, just how you do your work, how you do it, how you release that point, that's what we look at. You have realized you may have a weak point, but the manner in which you just put it convinces the court that even though the point is weak, but you have persuaded me. That is one other thing. They have also looked at it. Time management is very important. That's why the rule said 20 minutes and then 5-4 rejoinder. So we were also looking at which team is good in time management. and the response we have, most of you were able to do it. Though when you start in the beginning, you have 20 minutes, and if you are 3 oralists, then it means how are you going to do that division of labor? How are you dividing your minutes? So as you look at the timer, if you said I'm going to take 8 minutes to discharge my part, were you able to do that within that time you said? And most of you were able to do that. Then teamwork. Teamwork means the 3 oralists of you. How did you distribute your work within yourselves? Most of you, that is what you were able to witness, save for a few. A few, I thought it was only in this court. I realized also from the feedback, this was also the same in the other courts. You would have only 2 oralists. Why that was decided, we are unable to tell. But you see, if you are being scored, the 3 of you, and the only 2 submit, look at how when you are looking at the average, the other one will be out of 3, the other one out of 2. So maybe this is a point to take home. Next time you appear, endeavor to have the 3 of you submit. So as that is how teamwork is also measured. So as we don't have 3, but only 2 are able to testify. The way you showed your respect for the court mattered a lot. We had marks for courtesy, we had marks for etiquette, we had marks for all that. So it also just depends on the posture, how you bring out your argument, and how you talk back, or how you respond back to the court or to your colleagues, how you just carry out. Even your body language will tell us if you carry semblance of respect, or if you are demeaning something or a point. Also how you are responding back, like when you come for a rejoinder, how do you do it? Do you do it to demean your co-counsel who had submitted on a point, so that you are trying to prove that they are of less knowledge, they do not know what they were talking about? That one also counts much, because in court we expect, as we grow up, we are coming up with people, when they submit, they will show respect for one another. You have seen what happens in court sometimes. So we are also looking at that to ensure that we are well guided. Our colleagues who looked at the memorials, we also noticed something. Quite a number of you were able to stick to your memorials, but in some instances, if you are to submit on a certain point, you are dealing with the first issue. Are you going to quote fresh authorities now on your feet? Are you going to refer to substantively part of your submissions which are not carried in your memorials? You look at how that sounds. It means you are not well prepared for that, because you are departing from your submissions, and that one, it's part of the rules that we provided for. There was a generally good grasp of the law, but the worry that has been pointed out across all the 4 courts was the issue of serious and heavy reliance on international instruments. We wanted to see a deeper exploration of the domestic plane. What is available? What are the case laws here? And that's where ingenuity of all this comes in. So we expected also that one to come up. We know AI is still a new thing. So an argument like should the law follow AI or AI to follow the law? What arguments can you develop around that? And what has the law or case law or even written works on that say about it. Then as I finish, I think I can just mention a few things which I think as we go along by Friday, we will also improve on it. And for those who will not make it up to the end, next time, this is now an annual activity, you will also have to improve on it. Time management, this one I had already mentioned it, but when you are preparing to come, at the back of your mind have 20 minutes. So as even when you are mooting in your department, do it within those 20 minutes. The more you do it within the 20 minutes, when you are on your feet here, the environment appears to change a little bit, but the time does not change. So you will refine your argument so as you hit the nail on the head once and you move on. So that one, I hope we will look at it. From now henceforth, for those teams who maybe you will progress ahead and you head to oralist, if there's something you can do about it, do about it. Then see if you can change the formation of your presentations. The local authorities, I already mentioned about it. There are very small issues which we take for granted, but you do not know the court before which you appear, how they look at those small issues. When you sit and you cross your legs, you don't know the court you are appearing before, how they look at it. When you speak and you are chewing gum, you do not know how that court looks at it. So those are small things, but they count towards etiquette. So those are some of the things which my colleagues noticed. Dress code. Did the rules provide for dress code? Yes, they did. Then when you appear before a bench, that is the first impression, which is the lasting impression when we see you. So as even on the second day or the third day, if we see you now properly dressed, we will say, this is the one who came not properly dressed for the occasion. So do not dress to kill, but dress modestly as a muta who is appearing before the court. So we hope that one should not reoccur if it occurred somewhere else. Audibility, I know sometimes you gain control of your voice as you go along, right? When you start, maybe sometimes you can start on a low tone, but as you progress, things keep on working better. The adrenaline becomes quite positive with you, and you perform better on that. Another issue which we need to work on, we have our own different styles and ways of delivering a message. Some of us, we will want to deliver it too fast, maybe because we are looking at the timer and we are like, if I talk too fast, I will save on time and speak more to it. But in the process of speaking too fast, sometimes the court will have a difficulty in following your thought process. It will look like you did a rehearsal, so what you are now doing, you are just mincing out what you had rehearsed on. We want to see you composed. The court wants to see you speak out of your heart, that this is something I have prepared for, and therefore it's not something I prepared overnight, and therefore I want to speak faster so as I don't forget the point I want to make. That one is one other thing we can try to see how to work on. The rules, they specifically provided that do not read, so as you don't come with a script which you are reading when you are doing your submissions. I liked those who had the yellow stickers, blue stickers, whatever stickers, meaning you know this is the point, so as you don't lose it. If it's jurisdiction, that is what you are talking about. If it's non-enrollment, that's what you are talking about. Maybe you have indicated somewhere there, the Refugees Act, the Refugees Convention, all those things. They are just things when you look at, you are able to pick up the other things. But when we see you, like you are reading from A to Z, it's like your level of preparation was a little bit down. Addressing the court, we provided for it in the rules. So maybe as we progress, before, we do not want to get to the finals before our Supreme Court judges and the other international judges who will join them. We do not call them Your Excellence, do not call them Chief Justice, do not call them Sir, Madam. Just stick to Your Lordship, Your Lordship, Your Honor. Maybe that is the less you can go, but let us just go back and look at how we are supposed to address the court. So finally, I already mentioned the issue of the posture. So that if I have been speaking here for the last maybe 5 minutes or 10 minutes, and this is my posture throughout, so you see what that portends to. Even you who is listening to me, you will start making some judgments. If my posture, I'm looking down throughout, it also gives a certain inference of what will be the end result. So these are some of the issues we picked out, but generally you are learned people. That one, there is no doubt about it. Listening to what we have listened to throughout the day, we have no doubt that you have all what it takes to make an argument before the Supreme Court. So on my part, I just wish you well and encourage you to continue making the best that you can out of this. So I will now allow our support team to read out the results so that we know who is progressing to the next level. But before he does that, we have certificates of participation for each and every one of you. These ones, we will issue them out, not today, because the competition has to come to an end before that one is done. Ensure that you have our contact, we have your contact, so that we will be able to communicate. But this does not mean you leave tomorrow. Continue attending up to the last day if your provisions to be in the city allows. So Walter, please come.
So thanks, Honorable Dear Sir, the difficult task, of announcing what we have been waiting for since morning. So in computing the scores, so we took into account, as you saw in the rules, 30% from memorials, 70% from the oral rounds today. So I'll just read the cumulative scores, although we can, just to save on time, we can show you later on the breakdown. But given that even on Friday we'll have awards for the memorials, so even those who will not be proceeding, don't go assuming that there's nothing for you. Maybe you'll be awarded for the memorials. So I'll start from number 16 in terms of the cumulative score. So once I read the team, you clap for them. Even those who had number 16, 15, whatever who are not proceeding, they did their best, so we'll appreciate them. So number 16 is SC018 with a score of 55.82. Let's appreciate them. So that's team 18. Yeah? Number 15 is SC014 with a score of 62.6. Yeah, so that's team 14. So number 14 is SC012 with a score of 63.75. Number 13 is SC04 with a score of 66.68. So thank you, SC04. Number 12 is SC06 with a score of 67.15. Number 11 is SC008 with a score of 68.58. Number 10 is SC010, yeah? So number 10 became number 10 with a score of 70.71. Number 9 is SC007 with a score of 75.84. Yeah, so these teams, we really appreciate you, but it's the next 8 that I'll read that will be proceeding to the quarterfinals tomorrow. So number 8 is SC015, that is 15, with a score of 76.8. Let's appreciate them. Number 7 is SC009 with a score of 78.57. Number 6 is SC002 with a score of 78.6. Number 5 is SC011 with a score of 80.79. Number 4 is SC016 with a score of 81.69. Now to the top 3. Number 3 is SC001 with a score of 81.98. I don't know whether to read number 1 first or to read number 2 first, but let me read number 2. So number 2 is SC013 with a score of 82.13. So the best team in the preliminary round is SC005 with a score of 82.3. Okay. So let's appreciate them. Okay. So in effect, just to announce, the teams proceeding to quarterfinal are 005, 013, 001, 016, 011, 002, 009, and 015. So those are the teams that will proceed to quarterfinals. So tomorrow morning we'll take a lot. We still want that the decision as to which bench you appear before and whether you are applicant or respondent will also be based on lots, so that it's not predetermined. So we'll meet here at 8, so that for that brief ceremony of taking, there will be no speeches as today. We'll just be doing the lots to allocate the codes and the sides you will be arguing on. So remember that from tomorrow is now knockout, yeah? This was cumulative, but from tomorrow you appear before the bench. So whoever wins in a particular bench now moves to the next stage of semifinals. Then whoever wins in the semifinal will meet on Friday for the finals. I think this is it. So I'll invite. Do you have anything else? Yeah.
So let us just do a good round of applause to everyone. So let us go and do the best practice we can for tomorrow, for the knockout. The competition is now becoming more and more stiffer than the way we thought. I will request, where is Gloria? Gloria, come and pray for us. We want to go home now.
Okay, let's stand for the word of prayer. Our dear Heavenly Father, we thank you for the first day of this moot. We thank you because it has been educative. We have seen you through all ways. We have seen more competition that we aspire to know more. Thank you for our judges and the willingness to be here. Thank you for the finances that you have provided for enabling this event to be successful. We thank you for all the teams proceeding. Continue guiding them. And for those who have not proceeded, Lord, we pray that they may be motivated for a better next time. And it is in Jesus' name I pray. Amen.
Hii ni ya Chebukati.